And Section 50 should clearly help us to understand what had to be done and assess the validity of what was done. The marginal rubric of Section 50 is review of constituency boundaries. And Section 51 says this: the Constituency Boundaries Commission, hereinafter in this section referred to as the Commission, shall, in accordance with the provisions of this section, review the number and boundaries of the constituencies into which St. Christopher and Nevis is divided, and submit to the Governor-General reports, either A, showing the constituencies into which it recommends that St. Christopher and Nevis should be divided in order to give effect to the rules set out in Schedule 2, or B, stating that, in its opinion, no alteration is required to the existing number of boundaries of constituencies in order to give effect to those rules. So that Section 51 gives a certain discretion to the Boundaries Commission to act and put certain procedures in place for the proper regulation of the constituency boundaries. But Section 53 is the pertinent section in relation to this draft proclamation. And I shall read it for you. As soon as may be after the Commission has submitted a report under subsection 1A, which I read earlier, the Prime Minister shall lay before the National Assembly for its approval the draft of a proclamation by the Governor-General for giving effect, whether with or without modifications, to the recommendations contained in the report, and that draft proclamation may make provision for any matters that appear to the Prime Minister to be incidental to or consequential upon the other provisions of the draft. That is Section 53, the section that regulates the laying of a draft proclamation in respect of the review of constituency boundaries. The House resumed on Thursday, 9th July, and the draft proclamation was debated in accordance with the rules of the House. An affirmative resolution was met, and the proclamation went off for signature and was signed by the Governor-General and gazetted in accordance with the law of St. Kitts and Nevis. So automatically, the proclamation, it is no longer a proclamation, had been incorporated into the legal framework of and the legal process of St. Kitts and Nevis. Now, later that same evening, this is Thursday the 9th of July, the Attorney General was informed by His Excellency that he was served with a court order the proclamation. Now, it's important to understand that what appears to be an unusual event, because the order was seeking to restrain him from doing something he had already legally done. And that's very important. He had legally signed the proclamation to give effect to the instrument. And sometime after that, an order was served on him seeking to restrain him from doing just that. The Attorney General was served on the following day with the same order. And on the following Monday, an application was made by the respondents to have the order set aside. Now, there are certain legal matters before the courts arising out of these applications. So the matters are sub judice, and one cannot properly go into discussion on these sub judice matters. But I think it is important for every single person to understand that there must be no shred of doubt that the Prime Minister has indeed acted with total legal propriety and has upheld the law in this exercise totally. The Prime Minister has acted in accordance with the law of the Federation of St. Kitts and Nevis, and that must be clearly understood. Thank you, ladies and gentlemen.